Morning, everyone. Welcome, Monsieur Fatin. Good morning, everyone. Today we are having our second meeting on Bill C-5. In our first panel, we have the Canadian Association of Black Lawyers. We have the Canadian Centre of Gender and Sexual Diversity, Disabled Women's Network of Canada, Women's Legal and Action Fund, Legal Education and Action Fund. And just to keep cognizant of the time, we'll get right to it. I'll ask the Canadian Association of Black Lawyers. You have 5 minutes to present your opening remarks, followed by questions from members. We'll go through 5 minutes from each of the witnesses that are here today, and then we'll open up the floor for questioning. So without further ado, Raphael Taki from the Canadian Association of Black Lawyers. Please go ahead.
Thank you so much. Thank you for inviting Cable to speak on this matter. We appreciate the opportunity to do so. So from Cable's perspective and the communities that we represent, the intention behind Bill C-5 is laudable. The idea that of judicial education around taking social context in sexual assault cases is something that we think is a positive step and should be lauded. However, we have a couple of concerns that we wish the committee to consider and take into account. The first concern really revolves around the idea of judicial interference of judicial independence. We query whether an undertaking to complete certain training or courses will be seen as an interference of judicial independence by the executive and legislative branches. The proposed amendment, furthermore, do not contain any enforcement mechanism where an individual provides such an undertaking and then later on does not fulfill the requirements. So without an enforcement mechanism, we question whether the perception of interference with judicial independence is really worthy at the end of the day. So that's kind of our first concern. The second concern we have revolve around the lack of definition of social context. The amendments, if the amendments are to proceed as drafted, we urge the committee to think about the differential impacts of the law on the bodies and peoples of Black and Indigenous and Black peoples. More specifically, when it comes to sexual assaults, whether as victims or as accused, stereotypes about Black and Indigenous people lead to differential treatment under the law, and these have different impacts on our bodies and our communities. Cable therefore urges the committee to include an express language relating to the experiences of Black
Pardon, sir?
people.
Just hold on for a second. I think we don't have translation. If you can just give us a moment to see if we can fix it. Just give us a second.
Okay.
As we're trying to figure out the translation for the video conference, I'll ask the next panel of witnesses to go ahead, and we'll come back to you. We'll come back to the Canadian Association of Black Lawyers. Please pardon the interruption as we deal with our technical challenges here. So I'll just turn to the Canadian Centre of Gender and Sexual Diversity, Cameron Aitken and Hannah O'Connor.
Good morning. The Canadian Centre for Gender and Sexual Diversity advocates for a world free from discrimination. To that end, we work through the fields of advocacy, education, research, and resource creation to support 2S LGBTQ+ communities across Canada. To support this mandate, we support teachers and service providers as they work towards bridging knowledge gaps around gender and sexual diversity. The Intimate Partner Violence Prevention Programme at the Canadian Centre for Gender and Sexual Diversity aims to increase capacity of LGBTQ2S+ agencies by providing them with the tools, information on resource and services, and training to support LGBTQ2S+ survivors of domestic physical assault, sexual assault, and emotional abuse, and to increase and equalise their access to the criminal justice system. We work with LGBTQ2S+ agencies, law enforcement, and non-LGBTQ2S+ organisations to create best practices to address the gaps in victim services and increase access to justice for LGBTQ2S+ people. These organisations include sexual assault centres, community resource, health centres, legal services, victim services, police units, sexual health centres, pride centres, university college programmes, and many others. We will work with any and all service providers across Canada who may come into contact with LGBTQ2S+ survivors of intimate partner violence and to increase the positive quality of these interactions. Looking at the proposed legislation, Bill C5, we support the rationale and in particular the following points resonate with our programme. And whereas reasons for decisions in sexual assault proceedings enhance the transparency and accountability of the judiciary, whereas survivors of sexual assault in Canada must have faith in the criminal justice system, whereas sexual assault proceedings have a profound effect on the reputations and lives of the persons affected and present a high possibility of re-victimizing survivors of sexual assault, in particular the importance of continuing education. Working with service providers across Canada, we are aware that ongoing education is a successful method of intervention in confronting bias for service providers. The formal process for survivors of sexual assault to receive necessary advocacy, health and legal supports is multifaceted and involves a multitude of service providers. At every stage there are barriers which can relate to the intersectional identities of survivors. Ongoing discrimination based on a multitude of factors and lived experiences can further compound and weaken the relationship between survivors, service providers and the state. Much of the same can be said for folks whose experience of sexual assault and violence also includes intimate partner violence. Members of the 2S LGBTQ+ community are, broadly speaking, more impacted by sexual assault and violence, and thus their lived realities need to be understood for competent services to be delivered. Working with social workers, HR professionals, medical professionals and other in-service provision, our aim in the IPV prevention workshops is to dispel harmful stereotypes and misconceptions that influence notions supporting survivors of sexual violence. Two crucial assessments include decoding which partner is the victim or abuser and providing services to transgender and gender non-conforming clients. Notions of masculinity and femininity, age and appearance can often impact how service providers respond to situations of abuse as they first assess and react to the situation. Through the 4 years this project has been funded, we have delivered roughly 300 workshops to service providers across Canada. Starting with a greater understanding of gender and sexual diversity, we transition into situations and problem solving which challenge existing bias. We have found that such trainings need to be ongoing and varied lengths, depending on the particular organisation, and we would encourage that the proposed seminars be lengthy. There are also provincial and regional disparities which require training sessions to always take into account local needs as they vary significantly. Finally, the organisations who participate are engaged in an ongoing process of ongoing education to continue to address personal, organisational and policy-based barriers. Our training and workshops succeed because the goal is to promote a mentality focused on social justice and trauma-informed care instead of a set curricula. I'll now introduce our Executive Director, Cameron Aitken.
You have 30 seconds.
Thank you. So it is on that basis that we want to say we support the final section of the amendment surrounding the criminal code and further information regarding decisions of cases related to sexual assault. We think finally that in regards to gaps, that we recommend that in addition to reporting on what seminars are offered, that the number of judges who attend said seminars and the names of those judges are disclosed in reporting, similar to a mechanism of enforcement. Finally, we recommend the implementation of reporting that asks judges to reflect and provide responses on how these seminars contribute to the incorporation of trauma and violence-informed approaches. We are concerned that the existing phrasing around the proposed seminars does not represent the diversity of survivors of sexual violence in Canada. In particular, considering the organizations present today, we feel that a further enshrining of diverse voices who represent persons, groups, or organizations the Council considers appropriate who support sexual assault survivors and organizations that support them. Thank you very much for your time.
Thank you, Mr. Aitken. We'll move to the Disabled Network of Canada, Disabled Women's Network of Canada. You have 5 minutes.
Good morning. Thank you. I'd like to begin by acknowledging that we're gathered on the territory of the Algonquin people and that we, that we are in a time of truth and reconciliation with all the Indigenous communities from coast to coast. to coast. We also want to thank the Attorney General and the committee for inviting us here today to speak and to acknowledge the important work of the other panelists who are also speaking today. In fact, LEAF, who are also joining us today, have been and continue to be important allies for us as they have supported Dawn Canada in several Supreme Court decisions which provide us with concrete, measurable evidence that the issue of myths and stereotypes related to victims of sexual assault have a particularly egregious impact on deaf women and women with disabilities, particularly women with mental disabilities, including learning, intellectual disabilities, psychosocial disabilities, and brain injuries. So let's be clear where communication and interaction with the victim may be different. We are here to discuss Bill C-5, an act to amend the Judges Act and the Criminal Code. We hope this legislation is enacted quickly, and we expect and anticipate strong, nonpartisan support from this committee. In preparing for today, I found something very interesting in the 2004 publication of Ethical Principles for Judges, not in the current draft, by the way, the 2020 draft. In the chapter that focuses on equality, Chief Justice McLaughlin and the committee chose to cite Eldridge specifically in the context of the risk of stereotyping. Dawn Canada were interveners in the Eldridge decision and in another very important decision that speaks to the myths and stereotypes that have been perpetuated in the courts and in society. DAI 2012. In DAI, the issues of myths related to sexual assault are central and make clear that judges are themselves subject to biases, including deep-rooted biases that are linked to systemic sexism, racism, and ableism. A review of Canley reveals 723 instances of Eldridge being cited and 152 for DAI. Also drawing from the McGill Journal, Law Journal, Janine Benedette and Isabel Grant on hearing the sexual assault complaints of women with disabilities, evidentiary and procedural issues. The tendency to infantilize women with mental disabilities contributes to sex discrimination against them by perpetuating stereotypes of asexuality and hypersexuality. When these women are analogized to children, sexual relationships are no longer seen as necessary or important for them, and they are depicted as asexual. Since no sexual activity is considered appropriate for children, the sexual activity that these women do have is then labeled as inappropriate, and they are also tainted, paradoxically, with a label of hypersexuality. The criminal trial process was not designed to facilitate the testimony of persons with disabilities. Oral testimony under oath, cross-examination, and the requirement to repeat one's story over and over again to persons in authority with consistency over a long period of time can present serious challenges to women with mental disabilities, yet these requirements are accepted without question as integral to criminal trial processes. An inability to operate within the confines of the traditional trial process may result in the diminished credibility of a woman's testimony or even in the granting of a stay of proceedings. The nature of the evidence received by courts in sexual assault cases presents other concerns. The routine use of sexual history, evidence, cross-examination on therapeutic and other third-party records to undermine credibility, and the requirement of recent complaint raise unique concerns for women with mental disabilities. We suggest that the myths and the stereotypes on which these devices rest remain. My final comment and reminder to this committee is that 24% of women in Canada live with a disability. That's the statistic, and that women with disabilities have the highest rates of sexual assault of any women and girls in this country. If we're permitted to share our recommendations, Karine Mirjani will share them. Madam Chair.
You have 30 seconds to share, but I do understand that you've presented with us a written brief, which will be translated with your recommendations to the rest of the committee. So you do have that, but you have 30 seconds if you'd like to make any additional remarks.
Parfait, je vais parler en français, so I'll be speaking in
Perfect, I'll be speaking in French. Thank you. I think it's very important that we ensure in the recommendations that training and intersectional sections is provided. We recommend that the training and the symposia be developed by women's groups so that they have appropriate expertise on marginalized women. Regarding Section 3, we understand that there is an issue of judicial responsibility, but all judges should participate in this symposia and be screened and monitored so that they can learn and ensure that these issues relating to systemic discrimination of the most marginalized women, be it deaf women or disabled women, who have a number of issues, are at the highlight of the training. Thank you.
Moving on to LEAF, we have Roselle Kim.
Good morning. My name is Roselle Kim. I'm a staff lawyer at LEAF, the Women's Legal Education Action Fund. Thank you very much for inviting LEAF to speak on this issue. Over the past 35 years, LEAF has played a key role in advancing women and girls' substantive equality rights in law through litigation, law reform, and legal education. The advancement of sexual assault law through a feminist and equality lens is a fundamental element of LEAF's work because freedom from violence is a necessary condition for women's equality rights. LEAF recognizes the symbolic importance of this bill and supports judges receiving training on sexual assault. However, we also believe that the bill requires certain specification about how this training should be implemented, details of which I'll discuss later on. I'll begin by discussing why LEAF supports specialized judicial training on sexual assault. Despite a cultural shift in how we talk about sexual assault, we continue to witness profound misconception about sexual assault complainants in the courts. For close to 30 years, Canadian law has said that a complainant's previous sexual history should not play a role in determining whether the complainant is believable or whether the complainant consented to the sexual act in question. Yet trial judges continue to get it wrong. Their errors are frequently rooted in harmful myths and stereotypes, and probably not coincidentally, a lack of understanding about the legal definition of consent, like the belief that if you weren't actively fighting back or yelling out, you weren't really saying no. Recent cases have seen trial judges acquitting the accused or questioning the credibility of the complainant because a complainant didn't close her knees, because she was wearing a loose-fitting pajamas with no underwear, because she didn't immediately leave, because she had consented before. Training is also necessary because, in order to combat such myths and stereotypes about complainants while still respecting the rights of the accused, sexual assault law has become very complex. Many judges have had little to no experience in criminal law before being appointed to the bench, and it's difficult to imagine that they'll be able to preside over a sexual assault hearing without training. It's left to the appellate courts then to correct the errors in law that are made in the lower courts. But not every case where trial judges make these mistakes is or can be appealed. Even where an appeal is allowed, this may not feel like a victory to the complainant, who will once again need to tell her story in a new trial. Judicial training in sexual assault is needed to stop these errors before they happen in order to ensure trial fairness, minimize re-traumatizing of complainants, and save judicial resources. For these reasons, among others, LEAF supports judges receiving training on sexual assault. But in order for that training to be effective, we believe the bill requires certain specification. First is the term social context, like the other witnesses have mentioned. The term should be defined explicitly as factors contributing to systemic inequality in Canadian society, which include colonialism, systemic racism, ableism, homophobia, and transphobia. Education about sexual assault cannot be conducted in a historical vacuum. It's necessary to understand how our history and current social conditions, such as ongoing impacts of colonialism, have led to and can exacerbate the proliferation of sexual violence and the myths and stereotypes about complainants. Judges need to understand that Indigenous women in Canada are 3 times more likely than non-Indigenous women to experience sexual violence in their lifetime. Judges also need to understand that women with disabilities are more likely to experience sexual violence than women without disabilities, as Dawn has mentioned. Similarly, my second point relates to Section 3 of the bill, which provides that materials will be developed in consultation with sexual assault survivors and organizations that support them. It's important that sexual assault survivors who are consulted also reflect the diversity of people in Canadian society, especially those who have lived through the conditions of marginalization, such as systemic racism, and directly understand how marginalization impacts their experience of sexual assault. We would ask that this section also include meaningful consultation and input from individuals with lived experience of oppression, particularly individuals or organizations that serve populations that are Indigenous, Black, racialized, live with disabilities, or live in poverty, among others. Seminars on sexual assault should also include the impact of trauma on the complainant's memory, demeanor, and well-being, which is currently absent in this bill. Trauma can also have a profound impact on how a complainant remembers the assault, as well as how a complainant reacts to it at the time of the assault, as well as in the courtroom. Finally, I would like to discuss Section 4 of the bill as it relates to reasons. In its current version, the bill only requires written reasons to be provided if trial proceedings are not recorded. Having publicly available written reasons would ensure greater accountability for the justice system by allowing legislators, researchers, and the public to access and review them. As the bill currently stands, any oral judgment entered into the record will still require someone to pay for and order the trial transcripts, which is costly and can be time-consuming. As an alternative, we suggest amending Section 4 of the bill so that where written reasons are not available in a sexual assault trial, the transcript of the trial decision only, and not a transcript of the entire trial, should be made available on publicly accessible domains. And this can be made possible by government providing dedicated funding for the transcript of the trial decisions. Thank you very much for your time.
Thank you very much to the witnesses. We will try to, because of the technical difficulties, get the panelists by video conference to come into our second panel. So for now, as we try to bring them back with proper interpretation, we'll go to our first round of questioning. And Mr. Lawrence, you're up for 6 minutes.
Thank you, and thank you all for being here and giving such a professional discussion, and thank you for doing the work you do in the community. It's certainly very important. I'd like to start with the folks from the Disability Women's Network of Canada. Dawn, okay, that's much easier, thank you. So I want to, I don't think you fully got the time to expand it, so I want to use this to sort of flesh that out a little bit more. So as my research has indicated, similar as you, that women with disabilities are much more likely to be sexually assaulted and then re-victimized. So I'm wondering if you could just describe for me some of the unique elements that if you're a woman with a disability going through a trial for sexual assault, we obviously know it's going to be horrible for any woman, but what unique elements might be there for a woman with disability?
Well, I'd have to say, based on an intersectional understanding of people, and especially in the context of this discussion, is that would depend on what her disability was, because what we need to think about, of course, is that accommodation and understanding, what is at issue for somebody is important. So there could be a number of factors, including her disability or accommodations for a disability. There could be the issue that I raised really clearly here for some women, communication, and making sure that they're supported in terms of communication. In terms of also understanding that presenting in plain language for a woman, depending on what her disability is, would be very important, and that's not always accommodated. And of course, I cite Eldridge not in the context of sexual assault, but in the context of a deaf woman's right to be fully supported through a process, which means from when she reports the sexual assault through the entire process, she's entitled to interpretation, to sign language or captioning, whatever she needs. And again, that individual should be able to identify what her disability support or accommodation is. In terms of the issues that women with disabilities face that are, I think, important to talk about, is that we're talking about, and a good example, I think, when we talk about Indigenous women, for example, is that if you talk about in the context of the Missing and Murdered Women's Inquiry, a lot of people may not understand this, but a high number of women that we were talking about in that context would have been women with brain injuries. Brain injury is a hidden disability, and consequently many people who have brain injuries, including women who experience gender-based violence and sexual assault, have a brain injury but are not aware and have not got a diagnosis. And the consequence of that is that she's undermined based on something that neither she or others understand. So I think there's a lot of different things we need to think about, but I think the most important thing we need to understand is that when we develop the training for judges, that the full breadth of that understanding needs to be there, that it's not a simple issue and that you can't put everybody in one box, and that when you're looking at sexual assault and the victim, you need to look at her from all those intersections: race, indigeneity, sexual orientation, and disability.
Do you have? Sorry, go ahead.
Yeah, and let
I'm
Kevin add
just
to
going to
that.
ask, I'm going to add something, and I think Roselle could add as well. Something that's very important to understand as well is part of the criteria that judges use to understand who can consent and who can tell the truth. Right? And also, how do we talk about consent? So when we talk about telling the truth, we understand that some women are able to tell the truth. And then judges and the law and past jurisprudence have told some women may be suggestible, may not be credible witnesses, right? If you can't make the sense of the time, and we think about women with brain injuries, for example, who are women with disabilities, sometimes times get muddled. The experience is still there, but the way that currently our criminal courts understand what's happening makes it that they're seen as not credible. They're seen as maybe being suggestible, especially for women with intellectual disabilities. If you have mental health issues, let's say you have schizophrenia or other disabilities. And I think it's important to go back to what Bonnie said, is that the reality of women with disabilities they're numerous. And not every single woman will need the same thing, but a lot of women with disabilities, especially when you think about the highest number of sexual assaults and violence in general is towards women with intellectual disabilities, they are not believed. Which is the case for all women, but especially for them. And there's legal ways that criminal courts have made that happen.
The GAO decision we referred to is one of the ones that really unpacks that. Oh, sorry.
No. Thank you. So one of the things I'm drawing from that is that in this training, one of the important things for a justice to understand when sitting before a case of a woman with an intellectual disability who's been a victim of sexual assault is that they need to understand the conditions, that the consent may be different for someone with an intellectual disability. Is that correct?
It's also important to remember around the myths and stereotypes, some of the things I mentioned before, the notion of the hypersexualization, these things are used and used to try and shape that there was consent as opposed to not being consent. I think that's really important to understand also.
Okay, and so this law or proposed law would benefit, you believe, in terms of helping judges understand that. Am I
Provided
correct?
the curriculum is intersectional and fulsome, yes, but it really needs to have that fulsome understanding of victims' needs.
Right.
Thank you.
Just one other question on that.
Sorry, Mr. Lawrence, you have 10 seconds left.
Really quickly, in terms of the victims of this, do you think the sentencing is appropriate, or do you think that there should be additional sentencing for folks who victimize women with intellectual disabilities?
Very brief
Currently,
remarks, please.
yes, currently, as far as I understand, there's sorry, I'm going to have to answer in French. Présentement, il y a des facteurs aggravants qui existent.
At present, there are aggravating factors regarding sentences. That does exist. People who are more vulnerable are affected, but we're not saying that there should be heavier sentences.
Thank you, Chair. Thank you to all the witnesses for being here and the good work that you all do. I think all of you testified when we were looking at the bill in the past. I'm not sure if Leaf did. No. Okay. But I know that Dawn and you folks did. So when we looked at the bill last time, we had a Crown prosecutor testify, and she was one of the most powerful witnesses I think I've ever heard. And one of the things she said is, I've heard that statistics that 1 in 4 women will experience some form of sexual assault in their lifetime. But in my experience, factors of privilege, whether you're white, whether you're educated, whether you're financially independent, and whether you're male, make us less likely to experience sexually assault. Ironically or not, these are all the same factors to tend to make it less likely that you'll be a judge. So while we're expected to rely on common sense and ordinary experience when it comes to sexual assault, most of us who work in the courtroom have none. I wonder if you could that's a direct quote. I wonder if you could speak a little bit about the importance of ensuring that the training is intersectional. We had quite a robust discussion in the last iteration of the bill about the exact wording that we could use that would be supported in the courts, and we ended up coming up with social context. The intent of that was to ensure that the training included sexual diversity, disabled women, women of color, women of various backgrounds. But how important is that training to ensure that it also includes that social context? And I'll maybe turn it to all of you if you want to start.
Hi, thank you so much. Part of what I think we were trying to convey earlier is that we work with service providers teaching about consent, and it can be a very challenging thing, and to teach about intersectionality. And so I think that it's absolutely important that the training takes into consideration things like power dynamics and all of these different identities, and the notion that that can make someone more vulnerable. And I think it's definitely a difficult thing to teach because there's no individualized curriculum. And that is one thing that I think could be accepted, and there could still be meaningful seminars around social context, but it would need to be done in a very holistic and meaningful way. It's not something that you can have one cookie cutter approach or workshop that will reach or resonate with everyone. I think that's what we're trying to convey in the work that we do as educators. Have anything to add?
I don't have much to add to that, but just to reiterate our stance that we really feel like this training should be ongoing. As Cameron said, this one-prong approach or cookie cutter approach, when you have so many subsects of, what does it mean to be marginalized? What does it mean to, be victimized, racialized? This is an ongoing thing. It's not going to be, a half day or a 1 day seminar where you're going to hit every single approach. And that's the point that we really want to drive home, is this is ongoing. Society is evolving, we're evolving. And I think that this needs to be taken into consideration.
Thank you. If you can be brief so we get to everybody too.
Yes, of course. So whether social context is important in this training, we would say yes, and I think that's because depending on the other factors of identity that you inhabit as a complainant, there's layers of stereotypes based on that. So how you experience sexual violence and how you are taken seriously or not seriously by the members of the justice system, and whether you're believed. I think these all depend on where you come from, and it's important to unpack that there are myths and stereotypes that exist about sexual violence in general, but also the fact that your experience of that violence may be exacerbated because of other factors of marginalization.
I'm just going to say something. I'll turn it over to Karen. It's the point I was making before about when we look at the when we look at the missing and murdered women's inquiry again, the disability lens was not added. And the consequence of that is one of the root causes was missed in terms of something that we invested a huge amount of money in. This idea that we cannot use an intersectional lens on any social or economic or societal issue is simply, living in the past. I think it's quite clear that we're beginning to move that way in terms of all types of legislation. And the reason that that's beginning to be the case is because it works better.
And I will add this thing that for me is really important is often we talk about intersectionality these days and we think about Black women, we think about Indigenous women, we think about women with disabilities, we think about trans women, but some of us are not just one. Some of us live those different things. And I think that's really important to go back to what Roselle said earlier about the experience of marginalizations. And some of us are marginalized in different ways. And for me, that's how a training addresses those stereotypes and systemic discrimination could be useful.
So I only have 30 seconds left. So just quickly to all of you, if you were asked to participate in training videos that they're working on, would you be happy to do that? Am I seeing a unanimous yes? Okay.
Absolutely.
Yes. Okay. I think that's it, Chair.
Thank you, Ms. for being very judicious with your time. I really appreciate that. Moving on to Monsieur Fortin. You have 6 minutes, sir.
Merci.
Thank you, Madam Chair. First of all, I'd like to thank you all for being here this morning. It's wonderful to see you contributing to consideration of this bill, which we consider very important. I'd like to focus on Ms. Kim's testimony on aspects of grounds for decision in transcripts. If I understand correctly, you're talking about partial transcripts, not full transcripts. I'd like to hear you elaborate. Would this apply in all cases where there have been declarations of guilt, statements of guilt, or when? Thank you.
I think I wanted the partial transcripts of the decision itself in sexual assault cases. And the reason for, I think, limiting it to the transcripts of the decision is that we understand that providing transcripts of all of the trial can be very costly and time-consuming. But given that there has been so much discussion about how sexual assault trials are run and what goes on in the sexual assault trial, I think having the decision itself that's put on the record be publicly available can at least provide the public with some kind of an accountability as well as accessibility of what the judge decided. And of course, there are instances like with Justice Camp that some things that are said in the courtroom and don't make it to the decision might not be available, but at least having the decision on the record available allows us to know what kind of decisions are out there, and that could really help with the research on the trends in sexual assault cases.
OK. Cette partie de votre témoignage.
I'm interested in that part of your testimony in paragraph 4 of the bill. In paragraph 4, it says an article is being added to the Criminal Code, 278-98, which asks judges to provide grounds for their decision. And full grounds are required, which would either be given verbally and put into the proceedings or written grounds. If I understand correctly, you wish to limit the explanation for those grounds or not? The reasons for decision. Have I understood you correctly?
Limit the grounds, and that was not what I meant by my testimony. It's just the reasons, even when they're given on the record, they might not be publicly available for people to access, because you would, if they're not written and if they're not published on CanLII, they would not be accessible by the public unless someone takes the extra step to go order it for themselves. So my point simply was that if the reasons are on the record but they're not written, then the decision itself that's on the record should be made available.
Okay.
The transcript.
Totally. Complètement.
I understand. So you'd like the full reasons for decision of the judge?
The trial itself, the whole trial, but just the day that the judge renders a decision.
Merci.
Merci, Monsieur Fortin. Moving.
Thank you, Mr. Fortin.
Choose to use them all.
Thank you, Chair. Thank you to all the witnesses for coming today and for your opening statements. One thing I've noticed in the discussion around this piece of legislation is there have been concerns expressed over, what role Parliament plays in judicial education. We heard from the Canadian Judicial Council, and the Institute who have stressed very much that this kind of training already happens. And there have been concerns expressed by some in the legal profession that, if Parliament intrudes too far with this bill, we are interfering with judicial independence, and so on. And we've heard from some of you, saying that possible amendments to this bill, maybe you'd like to see a little bit more specificity. I'm curious about that. I mean, there's, as the bill is currently written, it closely reflects the amendments that were made of the previous version by the Senate's Legal and Constitutional Affairs Committee. And there were feelings that this made it more in line with, the constitutional requirement of judicial independence. So, if we already have, a mandate that judges have to undertake to participate in continuing education. And the fact that we have a reporting requirement that has to include the information about the seminars. Ms. Kim, I'm just wondering, how do you see Parliament's role in this? And if you could just maybe elaborate a little bit more on the specificity you'd like to see in this bill with respect to how the training should include the diversity that is in Canadian society.
Sure. So I'll speak on the independence point. My understanding is that, it's the judges themselves that have recognized the existence of myths and stereotypes in sexual assault trials, beginning almost 30 years ago in decisions like Seaboyer and as recently as Barton, that there are significant issues in how trial judges continue to engage in myths and stereotypes about victims. So in a way that this need for judicial education was actually first signaled by the judiciary, and this could be seen as a Parliament responding to what the Supreme Court of Canada has pointed out over the last few years. And if we see this kind of training as strengthening judicial competence to prevent errors in law, then this purpose of the training is to ensure that judges are well versed in a very complicated area of the law, and we don't think that this, this encroaches or this is. We believe this is well within the boundaries of judicial independence. As relates to social context, I think that it would just be helpful to have a definition of what social context means. And I know that the mandate letter also relates to, has signaled certain things like impact of trauma and other and unconscious bias. So what we would like to see is just the fact that the social context is linked to factors that have led to systemic inequality, that have exacerbated these harmful myths and stereotypes in Canadian society.
Yeah, I guess I'm just curious, do we serve the public well by putting the specificity in the bill, or do we serve the public better by analyzing the reports that are going to be tabled in Parliament and then having a chance to review that education? So that, I guess that's what I'm trying to get at. And if anyone else has a comment on that question.
I'll just, go back to what I had said in my opening remarks in terms of the ethical principles for judges and the idea that this, going back to McLaughlin in 2004, citing Eldridge. Mm-hmm. And, like I said, if Eldridge is there to remind judges, then I think it's really clear. I would really agree with what she's already said, and just say that it's really important to understand that judges themselves, including McLaughlin and others, have often cited this idea that they recognize that this is something they need to address. And I think the specificity of them choosing Eldridge in that particular chapter speaks for me to the idea that you do have to be very clear. And that it is indeed, like I said, it should be embedded in judges' training. So, thank you.
I think there is a value to having some specificity, but also being open to the fact that our understanding of how systemic inequality has perpetuated is changing every day. But it is important to signal what we understand to be factors in systemic inequality so far, such as the ongoing impacts of colonialism and systemic racism that we understand to have played into the harmful myths and stereotypes, but keeping it as an open and evolving list, I think, is a good idea.
Do you have anything to add in the final 3 seconds? No?
Just very briefly, I think that's definitely a great point of how best to capture the spirit of those trainings. But again, in our experience, especially doing trainings with a lot of institutions, is that it can also go really poorly. And it can end up kind of serving a counterproductive purpose. And it can end up, if it's done in a way that is not intentful, that does not have all of these layers and impacts, it can be so counterproductive that then it makes it even harder to have redress. And so I think making sure that it's very intentful from the onset is kind of a way to approach the process successfully.
Thank you.
Thank you very much, Mr. McGregor. Given the time that we have remaining, I will split 3 minutes for the Conservatives, 3 for the Liberals, and then 1 each for the NDP and the Bloc for the remaining time for any questions that you have. So we'll start with Ms. Dancho.
I just want to say thank you very much for each of you being here. I feel that this issue is extremely important, and I'm very excited to see this legislation go forward. I do want to discuss a couple of the things that was mentioned. We know the purpose of this bill is to ensure victims of sexual assault and violence are treated with the dignity, compassion, and respect they deserve from judges. But beyond that, I believe that this legislation is aiming to create an environment where victims feel comfortable in a very otherwise intimidating environment, or at least a bit more comfortable, sharing their very traumatizing story. Now, a few of you have alluded to this, and I believe, Ms. Kim, you had mentioned that, and I know, Ms. Brayton, you had mentioned this as well, but in retelling this trauma over and over again to several different authority figures in intimidating environments, those details can sometimes be different in retelling, and because it is so traumatic and difficult to remember. In the education and the seminars for judges that is going to be created, what do you see that we can do to ensure those seminars and that education focuses on that, ensures that there is compassion and that judges understand that that there needs to be work done to understand that those stories, that shouldn't be used against them. I think that's what you mentioned, Ms. Kim, is that sometimes those details, those differences can be used against the victim, I believe that's what you said. What can we do about that? How can we build a seminar that educates judges to understand that this is traumatizing and they need to adjust for this?
I think there's a lot of psychological and neuroscience research out there on the impact of trauma and how it impacts memory. So it would be great to incorporate what's already out and accepted in the scientific community about how trauma can impact someone's memory, their demeanor, in order to sort of combat what we think a victim should behave or how the victim should tell the story. And that would hopefully inform what we think about how a victim should tell their story or how they should behave in a courtroom.
And I would add that everything that Roselle said is right, but sometimes discrepancy happen because of the way our brain works, because of what we remember. It can also be the way that we talk to different people. So the way that you might talk to your friend and the way you talk to a police officer might be slightly different than a lawyer or a therapist. And that sometimes the word that you use may be more clinical, but they're still the truth. They're still your truth, and that survivors should be believed.
And I appreciate both of those comments, and Ms. Kim, particularly the science of trauma. I think that's something that the committee and when creating these seminars and education should absolutely be factored into that education. Any more comments on that?
It's just, again, a reminder that, around how you communicate, what Kevin was saying and what she's saying, how you communicate, and understanding that individual accommodation is something that really needs to be ingrained in the way that the training is set up, so that it's understood that it's different and it's individualized, and that you really can't take a cookie cutter approach is, I think, the fundamental underlying thing we need to understand. And that as a consequence, what is appropriate trauma-informed counseling for one group of women may not have the same, address it the same way in another context. So I do think, like I said, it's, again, coming back to that intersectional understanding of what and how.
Thank you.
Thank you very much.
Thank you, Ms. Brayton. Thank you. Moving on to Mr. Virani, you have 3 minutes.
Thank you, Chair, and thank you again to all of the witnesses. So in these 3 minutes, I'm going to ask you a question. I'm going to ask all of you to respond to it in maybe about 45 seconds, so sorry for the brevity. But picking up where Ms. Demoff and Mr. McGregor were, we are struggling with unpacking the term social context, which I agree with you needs to be unpacked, but not being overly prescriptive in a way that potentially misses some groups. So there is language that's known to the judges and is also known to the mandate letter that Ms. Kim referred to, which is unconscious bias and cultural competency training. So what I'd ask each of the groups to do is just, if you could just respond to whether unpacking social context to include unconscious bias and cultural competency training would be an improvement to this legislation. So if we could start with Dawn, please.
I think I will go back to what we said, which, and you'll get that afterwards in French recommendations and English speaking notes. We work bilingually. But this idea that some of us are marginalized in different ways, I think is what we need to understand. And we also need to understand in marginalization and also what we know about the ones that are the most marginalized evolves in time. And that's important that the science about our unconscious bias and also so what does cultural competency means and for whom, right? Often we think about that for newcomers, but some of us were racialized, have been here for generations. So we need to improve and also think about deaf culture.
I think that having unconscious bias and cultural competence are good starting grounds, but I would just reiterate what I said earlier is that there should be some other signaling of the historical context of why we are where we are today, which, you know, we can also talk about the over-incarceration of certain racialized groups, and certainly I think the reconciliation part should be front and center in talking about the social context and ongoing impacts of colonialism.
Particularly, just going back to what everyone else has said about unconscious bias and stereotypes, like when you're talking from a 2S LGBTQ context, like false stereotypes around the 2S LGBTQ are just rife in society in general. And within the queer community, statistically, the people most likely to experience intimate partner violence and sexual assault are trans women, transgender women who are highly fetishized in our society. And the next most likely demographic are bisexual women. Bisexual women are highly, highly sexualized in our society. And just surrounding like stereotypes and unconscious bias, this can have an impact on everything to do with a sexual assault trial when it comes to witness statements. 2S LGBTQ people may censor themselves more. We're going back to the language that they may use. So I just definitely agree with what everyone else was saying regarding that social context.
Thank you very much for that. Monsieur Fortin, you have 1 minute.
Si. Alors,
Thank you once again. Thank you for being here. I understand that for a range of reasons you're very interested in this bill. Victims of sexual assault don't always have the credibility that they should have when they testify because the judge isn't necessarily conscious of their experience and may not be comfortable in court. This bill is supposed to mitigate those two issues. Are there things that you would recommend for the bill that would help victims to be perceived as more credible on one hand and also to be more comfortable during the judicial process?
I'm just going to again come back to the DAI decision, which centered around the idea that a woman with an intellectual disability is telling the truth, and if she's telling the truth, it's not. It's
always telling the truth.
What? I think I'm just trying to get to the point. Je m'excuse, hein?
I apologize if I speak English.
It is fundamental from the DAI decision, right, that the woman's right to be believed has to be centered. This is absolutely at the center of why I think this training is important, because the issue of believing women based on many different biases is why we need this.
Merci, Monsieur Fortin. Thank you. Mr. McGrath.
Thank you. I'll just make my question quickly to the Canadian Centre for Gender and Sexual Diversity. You had made mention of maybe further enshrining, making sure that diverse groups are enshrined. So as the bill is currently written, the Canadian Judicial Council is going to consult with organizations it considers appropriate, such as sexual assault survivors and groups and organizations that support them. Are you confident that the Canadian Judicial Council has the ability to consult in a diverse way, or do we need to amend that to make sure that there's specific language in there representing the diversity that we see in Canadian society?
I think that kind of the crux of our one program is that when you focus on kind of the main group of people involved in like the VAW sector and people who support survivors, you sometimes get one mold of feminism or one like overarching understanding of how things should be done. And so in the absence of it being very clear that it needs to be a smattering and not just like a traditional canon, and like which was really why we were so thrilled to see the other organizations that were being represented today, not only just sexual assault centers, but other advocacy groups that have specific identities and communities in mind. So from our experience, if we would feel more comfortable with it being as specific as possible because of our experience trying to support service providers in the VAW sector.
Thank you.
Just very quickly, I don't think anything can be lost from being more specific with the language.
In this particular section. Thank you.
Thank you very much. To the witnesses, if you feel that there are some additional recommendations or clarifications that you need to provide, please do submit written briefs just addressing some of the questions that were raised today. If in the next week or so, we'd really appreciate any additional information you provide. But thank you for being here today. Thank you for your remarks. I'm going to suspend the meeting for 2 minutes as we switch panelists. Thank you. Thanks, everyone. Welcome to our second panel on Bill C-5. Thank you to the witnesses for being here today. Thank you for your patience to Raphael Taki, and I see that you're joined by Laurie-Anne Thomas from the Canadian Association of Black Lawyers. We also have by video conference the Canadian Centre for Child Protection, Ms. Monique Saint-Germain. Welcome. We have Colchester Sexual Assault Centre, Sarah Fleming, and we have Kawartha Sexual Assault Centre, Jess Grover and Amy Crowis. Thank you for being here today. We're going to go to our video conference first. So we'll start with the Canadian Association of Black Lawyers. You have 5 minutes to make your opening statements. Thank you.
Thank you so much. And thank you to the committee for inviting us. We really, in looking at the bill, we think the intent behind the bill is laudable, and we support the general approach to considering the social context surrounding sexual assault in judicial training and education. However, we have a couple of concerns that we would like the committee to take into consideration. The first concern relates to the idea of or the appearance of judicial interference that the act creates. We query whether an undertaking to complete certain seminal training will be seen as interference of judicial independence by the legislative and executive branches of government. Secondly, related to that is the proposal that the amendments do not contain any enforcement mechanism if an individual undertakes to go through this seminar and then fails to actually go through once appointed. There doesn't appear to be a mechanism to enforcing that piece. So in that context, we query whether the appearance of judicial interference is worth it, especially when you consider that there's the Canadian Judicial Council, which currently provides training to judges on these type of issues. Maybe the concern is coordinating with that branch or that entity to educate judges on these issues. So that's the first point I would like to make. The second point we'd like to make relates to the notion of social context. The proposed amendments do not define what social context means. Therefore, in looking at the fact that traditionally the law has had differential impacts on the bodies of Black and Indigenous people in Canada, we would like to see a more specific definition of social context that takes into account the stereotypes about Black people and Black bodies that lead to the differential impacts of the law on them, whether as victims or as accused in sexual assault cases. CABLE therefore would like to urge the committee to include such express language in the preamble and as well as in the body of the text that takes into account the lived experiences of Black and Indigenous people, both as accused and as victims of sexual assault. Thank you very much.
Thank you very much for your remarks. Moving on to the Canadian Centre for Child Protection, Ms. Saint-Germain, you have 5 minutes.
Thank you. Good morning. Ms. Chairperson and distinguished members of the committee, thank you for giving us the opportunity to provide a presentation on Bill C-5. My name is Monique Saint-Germain. I am the General Counsel of the Canadian Centre for Child Protection, which is a registered charity dedicated to the personal safety of all children and has been operating for over 30 years. For the past 17 years, we have been operating cybertip.ca, which is Canada's tip line to report the online sexual exploitation of children. Cybertip is a central part of the Government of Canada's national strategy for the protection of children from sexual exploitation on the internet. We also created and operate Project Arachnid, a global platform to reduce online child sexual exploitation. Every day, our agency bears witness to the brutal ways in which children are victimized online. The vast majority of the reports we receive through Cybertip relate to images and videos, material that depicts very young, prepubescent children, many of whom are pre-verbal and cannot tell anyone about the abuse they are enduring. Most of these children have never been identified by law enforcement. We also work directly with survivors of childhood sexual violence, including those whose child sexual abuse was recorded. We know all too well the devastating and long-lasting impact that these crimes have on victims and their families. I am here this morning to express our agency's strong support for Bill C-5 and to put forward our recommendations to specifically account for children in this bill. First, the term sexual assault law is not defined in the bill. It should be crystal clear within the Judges Act that the term is meant to include all offenses listed in Section 4 of the bill. Second, the Criminal Code offenses for which a record must be created does not include the offenses related to commercial sexual exploitation of children or sex trafficking. This oversight must be rectified. Consideration should also be given to including offenses that involve the use of technology, such as the offense of making child pornography. Third, the mandated inclusion in training that is set out in the new Section 60 sub 3 sub B of the Judges Act is incomplete when it comes to children. Topics that need to be included in training to be responsive to the needs of children include grooming. Grooming is a process by which an offender lowers inhibitions and gains access and time alone with children. We actively monitor reported case law related to sexual offenses against children, and it is clear that the Canadian courts need to deepen their understanding of this very common offender tactic. The age of protection or the age of consent. These criminal code provisions are complicated. They are specific to minors, and they reference concepts such as trust, authority, dependency, and exploitation, all of which are critical legal concepts when it comes to a child's capacity to consent. Dynamics of child sexual abuse. There are significant differences to consider between adult and child sexual assaults. The perpetrators are different. The extent of vulnerability is different. The tactics used are different. The rates of disclosure are different. Even the ability of the victim to recognize if something was or wasn't a sexual violation is different. All of these issues must be accounted for in any training if that training is to be responsive to children. The online terrorization and manipulation of children that occurs via technology is unprecedented in today's society. There are multiple complex criminal code offenses. We live in a world where children can be virtually assaulted, where live-streamed child sexual abuse is ever increasing. The impact on children of technology-related offenses can be as serious as offenses involving physical contact. It's essential technology-facilitated offending is included in this training. Finally, the history and purpose of various criminal code provisions that are meant to address the needs of children in the court process, such as testimonial aids, publication bans, and Section 161 of the Criminal Code must be covered. These are incredibly important for children. In closing, we see concrete evidence of sexual assaults against children every single day. Children are far too often the victims of sexual assault. It is imperative that judicial education accounts for their unique vulnerabilities, their status as independent rights holders, and all of the criminal code provisions that exist to protect their interests. Children deserve to be understood by our courts and to be fully accommodated through all court processes. Thank you.
Thank you very much for that. From the Colchester Sexual Assault Centre, Ms. Sarah Fleming, you have 5 minutes.
Good afternoon. Thank you, Madam Chair. I apologize for I had Mr. Chair. That's my own internalized misogyny. Honourable Cabinet members and all others present today, I am Sarah Fleming. My role is Executive Director of the Colchester Sexual Assault Centre in Truro, Nova Scotia. I'd like to thank you for the honour of speaking on behalf of Bill C-5 this afternoon. In our small town located an hour north of Halifax, we support Colchester County as well as 2 neighbouring counties with free trauma counselling, outreach supports at schools, and other organizations, workshops, and presentations all year round. We have 2 part-time counselors who have on average 450 individual counseling sessions and an unlimited number of drop-ins per fiscal year. We are in what is known as a current hotspot for sexual exploitation and trafficking. Court support is also something we offer clients, and we have had 2 clients in the last year utilize that service. I'm here today to offer my insight on an area that I feel will create ripples across the judicial process. It will see more victims and survivors come forward to have their assailants charged. It will create a higher level of trust between police, lawyers, judges, and the greater community. This bill is not asking judges to become partial to the plight of victims, but rather will allow them to perform their jobs through an anti-oppressive practice. Marginalized women are at a much higher risk of sexual violence and a much lower rate of reporting. I don't think we need to ask ourselves why this is. I believe we are well informed of the risk factors of sexual and domestic violence. I do, however, think we as a country do a poor job of implementing these practices and ultimately keeping women safe. We are, however, making progress where it counts. In my small town alone, our court system has developed a mental health and domestic violence court. In working with community partners, both victims and offenders are able to get the support that is needed to reduce recidivism while holding them accountable for their actions. I was once told not to come with a problem, but rather a solution. So my solution to supporting victim survivors, having judges trained in best practices while facilitating a more restorative approach when appropriate, is to have sexual assault and sexual violence cases be presided over under mental health domestic courts, violence courts where it's appropriate. This is not necessarily always best practice for everyone, but may be a way to support victims where it is needed by allowing them access to services that can keep them safe and prevent further harm from happening. I feel we need to broaden the collective lens of sexual violence, and by passing this bill, it is a step in the right direction. What would it mean for victims to feel that when they walk into a courtroom, they do not have to fear the repercussion of their trauma follow them throughout their life? We have an opportunity to hold offenders responsible and potentially provide them with an opportunity for what behavior is expected of them in a cab, at a bar, or in a 20-year marriage. The outrage of re-victimized survivors needs to leave only sexual assault in women's centers and enter into the realm of everyday conversation. I want to hear the retired men in my local Tim Hortons to discuss how no person deserves to be assaulted, no mention of how much they drank or what they wore, or questions of motives of money or fame. When I tell victims it's not their fault, I want them to believe me. I know that the justice system is in place to support them and to follow up. And in the event there is a not guilty verdict, the chance to know why, to understand due process and legal jargon, all while feeling in control and supported. Thank you again for having me speak on behalf of the Colchester Sexual Assault Centre, as well as Colchester, Cumberland, and East Hants counties in Nova Scotia. I look forward to hearing further updates and hopefully the passing of this so important and timely bill. Thank you.
Thank you very much, Ms. Fleming. Moving on to the Kawartha Sexual Assault Centre. You have 5 minutes for your remarks.
Madam Chair, honorable committee members, good afternoon. I'm Jess Grover, the chair of the board at the Kawartha Sexual Assault Centre, KSAC, and I'm joined today by Amy Crows, the board secretary. We're here to speak in favor of Bill C5. Each year, KSAC, located in Peterborough, Ontario, works with nearly 750 clients, receives nearly 1,000 crisis calls, and nearly 15,000 people take part in our prevention education program. I've been a volunteer with KSAC for almost a decade, and I joined the board in 2016. I am a survivor of child rape. The passage of Bill C5 will be a crucial beginning step in addressing rape culture in Canada. Rape culture is an environment that normalizes and trivializes sexual assault through pervasive rape myths. These false ideas about survivor victims, the nature and frequency of sexual assaults, are all disproved by the support work and research that sexual assault centres across Canada do. Rape culture is like dust. It floats around us, often imperceptible, especially if you aren't looking for it. It is tossed into our environment through the stories we consume and the biases we pass from generation to generation. As we interact with others in our society, it settles onto all of us. Every single person in this room is carrying a bit of this with us, and it weighs down our decisions and our actions. Unless we actively recognize and work to dismantle rape culture, it will continue to build up and weigh down our society. Make no mistake about it, the dust of rape culture floats through the justice system, and it will continue to collect on its inner workings until the system breaks under the strain of it. All of us in this room can name very public instances that have caused Canadians' faith in the judicial system to be eroded in regards to sexual assault, and they have directly impacted our work of sexual assault report and prevention education. This harmful environment in some courtrooms dissuades our clients and other survivor victims from pursuing criminal avenues, and it directly attributes to sexual assault case attrition. These instances are directly cited by our clients accessing support. We do not want to bias the judiciary. We do not want to tell judges how to do their job. We do not want to compromise the independence of Canada's judicial system. We support this bill because it will help address the biases that we know currently exist. We support this bill because we believe that education on sexual assault will directly impact our work. We want to stop feeling trepidation when we present the option of pursuing legal avenues to victims and survivors. We support this bill because we expect our government to listen to Canadians and ensure the fairness of our justice system. We support this bill because we understand that judges want to come to sound decisions, and this bill will help empower them to do so. We support this bill because we expect courtrooms to stop contributing to the perpetuation of rape culture in Canada.
Hello, my name is Amy Crows, and I'm a social worker serving on the board of the Kawartha Sexual Assault Centre. In addition to that, I've had the opportunity to work with survivors in multiple different contexts and multiple different roles. According to an April 2019 Department of Justice report, while sexual assault rates have remained stable over the last 15 years, over 80% of these incidences were not reported to the police. According to a collection of Justice Canada studies, the most frequently cited reason for not reporting was because people did not think that they would be believed. These studies also found that 2/3 of the participants were not confident in the police, the court process, or the justice system. Sexual assault cases are one of the only types of crimes where a survivor's character is put on trial. Survivors who agree to a court process will be asked to retell their story, recognizing that a lawyer is to dismantle it, call them a liar, and systematically pick apart their credibility. This process is being overseen and regulated by a person who may likely not have any specialized training on how to understand trauma, the impacts of it, or the societal influences governing their own bias. We do not feel this is a socially just or ethical practice. We all know the comments that have caused survivor victims and the general public to lose faith in the justice system. Comments such as a 2014 case where a judge said, "Why couldn't you just keep your knees together?" The same judge who on more than one occasion mistakenly called the complainant the accused. There have been other cases, such as a judge saying clearly a drunk can consent, or a lawyer asking whether the larger than average penis size of the assailant was attractive to the survivor. This was permitted in a court of law. This is how some survivors are treated by our justice system. Tell me, would you ask a loved one to report if you knew that this is what was waiting for them in the courtroom? This must change. Recognizing that rape myths impact every aspect of the justice system, the Kawartha Sexual Assault Centre has a working partnership to provide education to the police services in our jurisdiction. This training empowers officers to do their job in the best way possible by providing training on the neurobiology of trauma and evidence-based facts to counter rape culture. This training has received a positive response not only from the officers working with victim witnesses, but also from the victim witnesses that are working with the officers. Through this bill, we may begin to change the relationship between survivors and the justice system, and while it's only a small step in the right direction, it is valuable movement towards building trust. Thank you.
Thank you very much for the testimony to all of our panelists. We really appreciate you being here today. Just being cognizant of time, I'm going to say that the first round of questioning, where we normally have 6 minutes, I'm going to cut it down to 5 minutes so that we can get to our second round of questioning. With that, Mr. McLean, I believe you're up first with 5 minutes. Thank you.
Thank you, thank you, Madam Chair, and thank you everybody for providing us the testimony you provided today, and thank you for the great work that you do in helping victims of sexual assault. I'm hoping you could provide us with some details of the support you provide your clients, your friends, prior to them going to trial, and maybe some indication of what happens at trial that dissuades them further from, in the current regime, from presenting their case. If that's from each of you, that would give us more body of weight about how the necessity of what we're going through here is.
That's great. Realistically, there's not many that want to seek any legal counsel or go forward with any sort of criminal justice involvement whatsoever. Realistically, I think that's the fear of most people when they walk in, is that in order to receive services, they are going to have to disclose to a police officer that they have been assaulted. I can't speak directly because unfortunately I'm new in my role, so I don't have firsthand experience in walking a victim or survivor through that process. However, that has been my experience with anyone that I've met so far, is that the fear of disclosure, because they will have to press charges. Yeah.
So at our center, we also provide something called accompaniment, which offers a survivor an opportunity to have somebody with some specialized knowledge go with them whenever they are accessing any of the different types of services, whether that be the hospital or the police station or the court process. And I think that timelines is something that's always an issue, but I know that that's not being addressed specifically with this bill. But the how will I be treated? What can I expect? How will people believe me? I know I said that in my 5 minutes, but that is one of the biggest concerns that people have, is that I know what happened. I know that I can tell my story, but will everybody else see it the same way that I do? Will everybody else understand what transpired? That is probably one of the biggest concerns that survivors have, is, do I want to put myself through do I want to put myself in a really vulnerable position, knowing that I might not get the outcome that I want to get because there's often a lack of forensic evidence, and put myself through years of potential re-victimization and re-trauma?
And just to add to that, one of the things that we talk to folks about, both the police and our clients, is around the neurobiology of trauma, which really impacts what can happen in a courtroom. When survivors are in a courtroom and they are facing a barrage of questions and often are being questioned in ways that are similar to internal monologues that have happened many times, and they feel that secondary victimization, we know that happens, it actually impacts their ability to recall accurate information. It directly impacts their ability to do so. And so what we know is that we need to prepare them to withstand more trauma in order to tell their story. And so we work with them to prepare them for that.
When it comes to children, the additional difficulty would be they don't necessarily have the language or the life experience to convey what has happened to them in a way that is meaningful and understandable from the court's perspective. So having the judge who is hearing the case have a better understanding of child development, child brain development, the impact of trauma on children, that is very, very important.
Anything further?
I think you're questioning the Canadian Association of Black Lawyers. Mr. Tacky, if you have any comments for Mr. McLean's question.
I don't have any comments on that point. We don't directly work with victims on sexual assaults and issues like that. We're usually advocating on the general issues that occur in the Black communities. Okay. So I wouldn't have much to add to that.
Mr. McLean, you have 20 seconds left. Would you like to use them?
I'll let that pass. Thank you.
Thank you. Mr. Zaberi, you have 5 minutes.
I'm sharing my time with Mr. Vrani, so would you like to go first?
Sure. I had a question. First of all, thank you to all of the witnesses for their testimony, particularly Ms. Grover. Thank you for your candor and for your very erudite presentation and your honesty. I wanted to ask a question of cable. You were meant to be in the last panel, and I want to ask you a question that came up in the last panel. We are struggling with the term social context, and you highlighted this in your presentation. It was a useful amendment in the last Parliament, but many, including me, feel like it needs to be unpacked a little bit. And the struggle that we are having is is trying to not be too prescriptive, where we might leave out certain key components, but also trying not to be too general, where we miss important concepts. There is a concept of unconscious bias that is known to the judges, and we understand that they're already receiving training on unconscious bias. And there's also a term called, that is probably familiar to you, of cultural competency. So I was wondering if you could provide us your view and the view of CABLE on whether improving the section that deals with the training to state something along the lines of training on sexual assault law and social context, including cultural competence and unconscious bias, would be an improvement in terms of being more directive in terms of the type of training that we want to see occurring.
Yes, so sorry, just so we had technical issues. So in terms of the social context, that is precisely our concern, is that the unconscious bias issues, the cultural competency issues, that's not addressed in this. And I know in the last panel there was some discussion of whether you can begin the training and then return to it later on to see what needs to be improved upon. In our submission, it really should be something that's considered, especially when you're talking about known phenomenon of the hypersexualization of Black bodies. And I believe the same would be true for Indigenous bodies. And so that is something that we want, that's something that we think is necessary in almost any training, given the overrepresentation of Black and Indigenous accused before the criminal justice system, as well as both not only in accused but also as victims in personal injury cases in sexual assault.
So I just want to shift the theme for a moment and go towards young people and children. First off, I want to thank Ms. Grosvenor for your touching, not touching, but for being so honest with us with what has happened to you in the past. This is a question around children, essentially. Do you feel right now that the courts are in a position where judges actually are able to appreciate the experiences of young people, the trauma that young people have suffered, and can fulsomely take in their testimony in a way that will allow for justice to be served? You guys can both comment on that for both Ms. St. Germain and Ms. Grosvenor, please.
Absolutely. Do you want me to go first?
Yes.
Okay. I think that when it comes to the court system, we have an excellent judiciary. We have different levels of competence and knowledge when it comes to children and specific issues surrounding children. So, for example, our judges who practice in family law areas would have a lot of different pieces of information and knowledge about children and child development, and they would have some of that because of the type of work that they do. Our judges who hear criminal cases may not have the same kind of information and training. And what we find is an evolution in terms of the judgments that we review, where the language that is used, the understanding that is expressed can really vary from judge to judge considerably. So training that takes that into account and that helps to level the playing field a bit and provide all of the judges with information that's relevant, I think would be much better for children.
Thank you.
And we know that trauma affects developing brains differently and permanently often. It doesn't necessarily permanently affect functioning, but it affects how your brain works, where things happen. And so it's really important that when we are talking to children, that we recognize that not only is development a spectrum, but that it is impacted by trauma, and understand like that is a very specialized form of even, psychology. And so ensuring that that is part of training and understanding is incredibly important in order to find justice for child survivors.
Thank you very much for those comments. I really appreciate it. Monsieur Fortin, you have 5 minutes.
Merci. Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you to our witnesses. Your participation is very important. Clearly, we all agree that we have to protect victims more effectively, and we have to help the justice system learn how to deal with these issues. I'm particularly troubled by children who are victims of violence and sexual assault. We've been hearing a lot about it lately. I do agree to a great extent with what the witnesses have said. But there is a process, Ms. Saint-Germain spoke about it briefly, with youth, where judges work daily with youth. The approach is a little different. Children can be heard outside the hearing room. That makes them more comfortable. I'd like to know, first of all, do you believe that the training that is being suggested for judges with C5, do you believe that the training should be adapted on the basis of what happens with the youth chamber, if not directly, if not a direct copy of it, but should be similar? And moreover, what can be done to reduce the impact of sexual violence on children and to help them deal with the consequences? What can we do to help them bear witness and to mitigate the consequences?
From our perspective, I'm not quite sure that I understand part of the question, but if you're getting at the special sort of circumstances and treatment that happens under the Youth Criminal Justice Act, the Youth Criminal Justice Act is really about people who commit crimes who are children. And we're talking here about children who are victims. That's something that our whole legal system doesn't do a great job of recognizing. We're really good at recognizing the rights of children accused of crimes. There is definitely going to be ways to reduce the victimization of children through the court processes that has to do with a lot of the victim services that are provided around the country in terms of support persons being permitted in the courtroom. In all courtrooms, we know that that doesn't happen in all areas, despite the fact that it is clearly in the code. We also know that there is a tremendous gap in victim services, not the ones that are delivered through courts, but that are delivered after the trial is over, because for the child, the trauma is not ended. The trial may be over, and from the criminal justice perspective, it may be over, but for the child, that victimization can go on for a lifetime, particularly if that child had imagery created of the child, of the sexual assault, because that can circulate online indefinitely.
Madame Groover, maybe?
I don't have
Ms. Groover?
to what my colleague said, but you may have additional to say.
So the only thing that I would like to call attention to, just based on what our colleague said, was that the Kawartha Sexual Assault Center funding only supports us working with youth and adults who are over the age of 12. So we are not in a position right now to be supporting these children as they work through the court process or directly after with their journey of healing after their experiences of trauma.
C'est assez terrible.
That's dreadful in practical terms, and I understand that it can be very troubling for a child to appear in court. But in Quebec, we have the concept of a youth offender, and we deal with youth offenders differently. There is no similarly different approach for young victims. Do you have any concrete suggestions, any of you, recommendations, practical recommendations that we could add to this bill in order to improve the way in which we can support children and young people as they go through the court system to witness as witnesses?
Faire témoigner hors cours.
For example, have them testify outside the court, away from away from the presence of the accused? Is this something that would help children?
Serious apologies. You're completely out of time. But I'm willing to, if one witness wants to, if you can pick one witness to give very brief remarks on that, please.
Okay.
Yes.
Okay. So just to say, that's actually something that occurs anyways at this point. So right now, if there are vulnerable witnesses, be they adults or children, they can testify in another court, in another room. There's mechanisms that are in the current criminal code that are essentially almost by default, and that defense would have to argue why such mechanisms shouldn't be used, such as having a child testify in another room or testify behind a screen or by video link. In addition, some courthouses, at least in Toronto, do have support animals for victims as aides, and so there are things that are currently in place. And I don't know, I think that's already in the criminal code, but I defer to anyone else if there's any other improvements that they can seek.
Thank you.
To address that.
Thank you very much, Ms. Thomas. We appreciate that. Mr. McGregor, you have 5 minutes.
Thank you, Chair. My first question will be to the Canadian Association of Black Lawyers. You did state that you had some concerns, like you said the goals of the bill are laudable, but you had some concerns over judicial independence because through this bill we are requiring applicants to undertake to participate in education on sexual assault law. Could you not argue, though, that we still are respecting judicial independence because we are going to have no role whatsoever in how a judge uses that education, and they are still going to be completely free and impartial when they are presenting their decision in a particular case? And my second question would be, if not through this bill, what role should Parliament play in making sure our judges are accountable? Because we have seen recent examples where judges are using outdated myths and stereotypes. So I'd like to hear your thoughts on those two questions, please.
With respect to the Act, I think the reporting certainly addresses some of that concern. All judges, because this would really only affect new judges, those who haven't been appointed as yet, all judges are subjected to new judges training. So we do think that the new judges training should be the area where it's specifically addressed in terms of this type of training and the mandate in terms of this training. The concern we have is not so much with respect to this specific area, but the concern is that once you open the door to mandating those who are applying to be judges to have certain types of training, that will be something that can be used, is essentially the slippery slope argument, which can be used not by your government, by other governments for other training that may not have as, again, a laudable reason to have in place. We think that these trainings, especially with respect to what both before the presenters at this time and the previous panel, we think all of that should be in consideration and should be taught on an ongoing basis. So we think the training is absolutely necessary. We just have concerns about the mandating or the undertaking for those who are applying, because again, it opens the door to other requirements for those applying to be judges in the future, and that's where we have some concerns in terms of the judicial independence. But in terms of the training, we think it is important, and we do think that reporting is important as well.
Mm-hmm. And the role, what role do you think Parliament should play then? That was my second question.
The role that Parliament can play is making sure that the appointment process appoints not only legally competent lawyers, but also suitable lawyers that have the character as well as the social awareness to be able to act as judges, to reflect the values of the Canadian community at large. To me, that means looking at the people we appoint and the process in which we choose people, but not mandating that they meet certain requirements, training requirements as part of the appointment process.
Ms. Grover, you expressed strong support for the bill. There are some differences in this version compared to the version we saw nearly 3 years ago. Are you happy with how the bill is currently written, or are there some specific amendments do you think we could make use of?
Thank you for that. I feel relatively comfortable with it. I would state that, particular the term social context can be one that's challenging. I recognize that there also can be trouble when you start listing out identities or areas that need to be focused upon. But I want to ensure that I think the spirit of the bill is quite good. And in particular, I believe that having judges disclose the reasonings for their decisions is really important in terms of checking in to why decisions were made. So in my analogy of rape culture being like dust, you've got to kind of pick up and look behind everything to see where it is. Otherwise, you're not going to find it. And so I feel like it's important for accountability and for transparency to ensure that that is there. I obviously would love to see more done in terms of ensuring that to ensure that the whole judicial process is safer for, and there's less secondary victimization, but of survivors. But I recognize that scope is very large, and we're discussing this today.
For sure.
I think the changes were good, though, between the two.
Okay, thank you.
Thank you, Mr. McGregor, and thank you, Ms. Grover. Moving on to the second round, we're going to be restricting to 3 minutes and continuing. Mr. Lawrence, you have 3 minutes.
Sorry, hit the thing twice. My questions will be for you, Ms. St. Germain. So just wanted to, I think you have some excellent ideas here specifically, but there are 3 areas where I think you wanted to see an addition. You wanted to see children specifically included, people, women, I guess people in general abused virtually, as well as victims of human trafficking. Have I that correct? And I was recently actually at the International Women's Day luncheon. I had the pleasure of hearing a victim of human trafficking, and she described her time as being raped for 3 months. So could you just, it might seem obvious, but I want to get on the record, in your interactions with victims of human trafficking, are they any less traumatized than sexual assault victims?
No, they are absolutely very, very traumatized individuals. And in fact, one of the things that we have really noticed, and it's very striking, because we monitor case law from across the country, reported case law, and we monitor human trafficking cases that involve children specifically. And what we have noticed is that almost never do those victims file victim impact statements. Almost never is there any information brought forward before the court about the long-term and ongoing impact that may accrue to these individuals. And we have noticed that it is a really, really significant thing, because when it comes down to sentencing in particular, if the judge doesn't understand the victim impact, that's supposed to be one of the criteria that they look at. They can't understand it if they don't have a victim coming forward to say something. So we see that problem with children. We see it with human trafficking victims who are children and commercial sexual exploitation. So those provisions having been missed in the list of criminal code provisions was a bit shocking.
As I said, just to get this on the record, I have an idea what your response will be, but they would be, insensitivity would re-victimize them just as much as any other victim of sexual assault.
Yes, absolutely.
Thank you. Do I have any more time?
You have about a minute.
Okay, perfect. And I'd like to actually go back now to the Canadian Association of Black Lawyers. And so my question is this: Justice McDonald, of course, came to our committee. Not that you have the view of the amendments, but he suggested a series of amendments that would perhaps soften the law with respect to it less telling the judiciary. And I think generally, a characterization might be working with the judiciary. Would you be would that be an amendment that you'd be more agreeable with?
Very briefly, Ms. Thomas.
especially with respect to the education, would be, I think, more favorable than the way it is currently articulated.
Thank you very much, Mr. Lawrence. Thank you. Moving on to Mr. Sangha, you have 3 minutes.
Thank you very much. Thank you everyone for coming today, for giving the valuable input. In this Bill C7, the major which we are studying is that Canadian Judicial Council will have seminars, how to impart the training to the judges, new judges. And in that, they will have the suggestion from like you and the groups, different groups, social groups, and to build the seminars. So those seminars will be imparted to the judges, those who are coming for the training. Now, we have heard different type of, from yesterday onward, from many sectors, people have come here to give their organizations, associations, to give their inputs. And it's regarding seniors, children, women, different type of other communities, and you people are doing the great job representing separate sectors of the community. Now, my question to you is, we have to keep the independency of the judiciary one side. His question is the same repeated one. It is asked many times, but still, especially you have to please give your points on what you want in the seminar to be included for the training of judges, so that we ensure that best judicial training is being given to the judges, and it is comprehensive, it is inclusive. Keeping in mind that those judges, they are already having best experience, 10 years experience they have got as a lawyers, and they were in the communities, they know many things, and still we want to give them training regarding the sexual assault cases.
Thank you. You have
so give the points
1 minute.
One little bit idea what you want to be included in the seminar.
You have a very 30 seconds for a brief response. Thank you.
So I guess to speak to the question is what do we want to see in the seminars for judges that is specific to sexual assault training? So ideally, I think if we look at the fabric of Canada and what is the what most judges look like, they don't necessarily match up. So from that perspective alone, I think it is beneficial for judges, with all of their experience, to understand what it feels like to come from the perspective of a survivor from marginalized people. And I think with that and hearing in first voices can only be helpful for them when they preside over sexual assault cases.
And very quickly, just to say the neurobiology of trauma, training about what trauma does to someone. And that based in science, based in what we know, based in research.
Thank you. Thank you very much for that. Monsieur Fortin, you have 1 minute.
Merci.
Thank you, Madam Chair. My question can be put to one of you. The bill provides for, we already know that to become a judge, you have to be practicing law for 10 years in the jurisdiction in which you are, and that there's ongoing training. Do you believe that it would be useful to add an additional condition to the appointment of judges, training on sexual assault? I understand you support the bill. Do you think it seems sufficient, or should there be an additional condition on the appointment of judges, that they should have taken the training?
Yes.
Yes.
Yeah, absolutely.
Yes.
Yeah.
Come.
I think that ideally,
what condition?
Having it sort of sexual violence court and be part of domestic violence. Judges that have shown that I guess that's an area of law that they want to practice or know more about, that can only be helpful in further presiding over those cases, just from that trauma lens.
Thank you very much, Ms. Fleming. Thank you so much, Mr. Fateh. I'm so sorry. Mr. McGregor, you have 1 minute. Thank you.
Thank you. Very quickly, I mean, this bill by itself is not going to fix all the problems we see in our justice system. So maybe very quickly from each of you, what does additional federal support look like beyond the courtroom? And I know that's a big question.
I mean, this is maybe so simple to say. We do what we do on a shoestring budget. There is so much we do. It costs us roughly $50 for an hour of one-to-one counseling, which is extraordinarily affordable in terms of value, right? Any money we can have that allows us to do work, and particularly allows us to do work with underserved populations. We receive funding to work with women. Where are trans and non-binary folks? Where are men in this? There are gaps, and I mean there are pockets of money, but there are gaps that happen when the funding is dispersed in that way. We work with survivors. We work in our communities. CASAC serves 4 counties. We know the needs of our community. Trust us to meet them. Give us some resources.
Thank you very much. And that is a wrap. I really appreciate all of the witnesses. Your remarks, your testimony has been very helpful to us. If there is additional information based on the questions that you would like to provide us, please don't hesitate to submit a written brief at your earliest convenience so that we can include that in the deliberations of Bill C-5. Thank you once again for your remarks, and looking forward to continuing this study. Meeting adjourned.